Today, we will understand the important duties of an agent under the Indian Contract Act. An agent acts on behalf of the principal and is bound by duties based on trust, honesty, and care. These duties are: first, the duty to follow instructions or customs under Section 211. Second, the duty of reasonable care and skill under Section 212. Third, the duty to maintain proper accounts under Section 213. Fourth, the duty to communicate with the principal under Section 214. Fifth, the duty to avoid conflict of interest under Section 215. Sixth, the duty not to make secret profit under Section 216. Seventh, the duty to remit sums under Section 218. Finally, the duty not to delegate under Section 190. Let us discuss these duties one by one. Let us now understand the first and one of the most important duties of an agent, the duty to follow instructions or customs under Section 211 of the Indian Contract Act. An agent is bound to conduct the business of the principal strictly according to the directions given by the principal. These instructions are mandatory and must be followed carefully. However, if no specific instructions are given, then the agent must act according to the customs or usual practices prevailing in that type of business at that particular place. In simple terms, the agent must either follow the principal's instructions or, in their absence, follow established business customs. Now, what happens if the agent does not follow these rules? If the agent acts contrary to the instructions or ignores the prevailing customs, and the principal suffers any loss, then the agent is liable to compensate for that loss. On the other hand, if the agent earns any profit by acting against the instructions, he cannot keep that profit. He must account for it and hand it over to the principal. To better understand Section 211, let us look at two important illustrations. First, illustration A. A is an agent engaged in carrying on a business for B. In this type of business, it is a common custom to invest surplus money, from time to time, at interest. However, A fails to make such investments. As a result, B loses the opportunity to earn interest. In this situation, A must compensate B by paying the amount of interest that would have normally been earned. This shows that even when no specific instructions are given, the agent must follow established business customs. Failure to do so makes the agent liable. Now, illustration B. B is a broker, and in his line of business, it is not customary to sell goods on credit. However, B sells A's goods on credit to C, even though C had a very good financial reputation at that time. Unfortunately, before making payment, C becomes insolvent. In this case, B must bear the loss and compensate A. Why? Because B acted against the established custom of the business, even though he acted in good faith. These illustrations clearly show that an agent must strictly follow instructions or prevailing customs. Any deviation can make the agent personally liable for losses. Let us now understand the duty of reasonable care and skill of an agent under Sections 212 and 214 of the Indian Contract Act. An agent is bound to conduct the business of the agency with the level of skill that is generally possessed by persons engaged in similar work or profession. However, if the principal is already aware that the agent lacks a particular skill, then the agent will not be held to that higher standard. Further, the agent must act with reasonable diligence. This means he must act carefully, attentively, and responsibly while performing his duties. The agent is expected to use whatever skill he possesses to the best of his ability. Now, if the agent fails in this duty, due to negligence, lack of skill, or misconduct, and the principal suffers a direct loss, then the agent is liable to compensate the principal. It is important to note that the agent is only responsible for direct consequences of his actions. He is not liable for losses that are indirect, remote, or not a natural result of his negligence or lack of skill. Let us understand this concept with an important illustration. A is a merchant in Calcutta, and he has an agent B in London. A certain sum of money is received by B on behalf of A, along with clear instructions to remit that money. However, B retains the money for a considerable period instead of sending it promptly. Because of this delay, A does not receive the funds in time and ultimately becomes insolvent. In this situation, B is liable to A. He must repay the money along with interest from the date it should have been remitted, calculated at the usual rate. Additionally, B is also responsible for any direct loss, such as loss due to fluctuation in exchange rates. However, B is not liable for further indirect or remote consequences beyond this. Now, the key point to understand here is this. If the agent retains the principal's money for an unreasonable period, it amounts to negligence. In such a case, the agent becomes responsible for the direct losses caused to the principal. But the agent is not automatically liable for the insolvency itself unless it is directly linked to his unreasonable delay. So, the essence of this illustration is that an agent must act promptly and diligently in handling the principal's money, otherwise he will be held liable for the direct consequences of his delay. Now, let us understand the second illustration related to the duty of reasonable care and skill. A is an agent authorized to sell goods, and he has the authority to sell on credit. In the course of business, A sells goods to be on credit. However, before making the sale, A fails to conduct proper and usual inquiries regarding the financial condition or solvency of B. At the time of the transaction, B is already insolvent. As a result, the principal suffers a loss because the payment cannot be recovered. In this case, A is liable to compensate the principal for the loss arising from this transaction. Why? Because the agent failed to exercise reasonable care and diligence. Even though he had the authority to sell on credit, he was expected to verify the buyer's financial reliability before proceeding. This illustration highlights an important principle. Having authority does not remove responsibility. An agent must still act prudently and make necessary inquiries to protect the principal's interest. Failure to do so amounts to negligence, making the agent liable for the resulting loss. Let us now understand the third illustration. A is an insurance broker employed by B to arrange insurance for a ship. While preparing the insurance policy, A fails to ensure that the usual and necessary clauses are included in the policy. Later, the ship is lost. However, because those essential clauses were missing, no compensation can be recovered from the insurance company, also known as the underwriters. As a result, B suffers a loss. In this situation, A is liable to make good the loss to B. Why? Because A failed to exercise reasonable skill and diligence expected from an insurance broker. Including standard clauses in an insurance policy is a basic professional responsibility. The omission of such clauses amounts to negligence. This illustration clearly shows that an agent must use the skill expected in his profession. If he fails to do so, and the principal suffers a direct loss, the agent is bound to compensate for that loss. Let us now understand the fourth illustration. A is a merchant in England who directs his agent B, located in Bombay, to send 100 bales of cotton by a particular ship. B accepts the agency and has the ability to send the cotton as instructed. However, he neglects to do so. The ship arrives safely in England. Soon after its arrival, the price of cotton rises in the market. Now, due to B's failure to act, A loses the opportunity to earn profit from the sale of those 100 bales. In this situation, B is liable to compensate A. However, the compensation is limited. B must make good the profit that A would have earned at the time when the ship arrived in England. But B is not responsible for any additional profit that A might have earned due to the subsequent rise in prices after that point. This illustration highlights an important principle. An agent is liable only for direct and immediate losses caused by his negligence, and not for remote or speculative gains. Thus, the agent must act with diligence and follow instructions promptly, or else he will be liable for the direct consequences of his failure. Let us now understand the duty to maintain accounts under Section 213 of the Indian Contract Act. According to this provision, an agent is bound to render proper accounts to his principal on demand. This means that the agent must maintain clear, accurate, and complete records of all transactions carried out on behalf of the principal. Whenever the principal asks, the agent must present these accounts without delay. This duty ensures transparency and accountability in the agency relationship. The agent cannot hide any transaction, misrepresent facts, or maintain incomplete records. Proper accounting helps the principal to verify how the business has been conducted and whether the agent has acted honestly. Failure to maintain or produce proper accounts may lead to legal consequences and loss of trust. So, the essence of this duty is simple. The agent must always be ready to give a true and complete account of his dealings. Now, let us understand the duty of an agent to communicate with the principal under Section 214 of the Indian Contract Act. This section lays down a very important responsibility. Whenever the agent faces any difficulty while performing his duties, he must use all reasonable efforts to communicate with the principal. The agent should try to inform the principal about the situation and seek proper instructions before taking any major decision. This duty ensures that the agent does not act independently in uncertain or complex situations where the principal's guidance is necessary. However, the law also recognizes practical situations. If there is an emergency and communication is not possible, the agent may act according to his best judgment in the interest of the principal. But in normal circumstances, failure to communicate when required may amount to negligence. Let us now understand the duty to avoid conflict of interest under Sections 215 and 216 of the Indian Contract Act. An agent is bound to carry on the business of the principal in the name of the principal and for the benefit of the principal. This means the agent must not use his position for personal gain or act on his own account in matters related to the agency. In simple terms, the agent cannot mix his personal interest with the interest of the principal. Now, what happens if the agent violates this duty? According to Section 215, if an agent deals on his own account in the business of the agency without obtaining prior consent of the principal and without disclosing all material facts, the principal has the right to repudiate or cancel the transaction. This right arises especially in two situations. First, when the agent has dishonestly concealed important facts from the principal. Second, when the transaction is disadvantageous to the principal. In such cases, the agent will also be responsible for any loss suffered by the principal. Further, under Section 216, if the agent makes any secret profit from such dealings, he must return that profit to the principal. Let us now understand this duty with the help of two important illustrations. First, illustration A. A directs his agent B to sell his estate. However, B secretly purchases the estate for himself, but in the name of another person, C. Later, A discovers that B was actually the real buyer. In this situation, A has the right to repudiate or cancel the sale. But this right arises if A can prove either of two things. First, that B dishonestly concealed any material fact, or, second, that the transaction was disadvantageous to A. This clearly shows that an agent cannot secretly act in his own interest. Now, illustration B. A again directs B to sell his estate. Before selling, B inspects the estate and discovers a valuable mine, which A is not aware of. B tells A that he wants to buy the estate himself, but he hides the important fact about the mine. A, being unaware of the mine, agrees to sell the property to B. Later, when A discovers that B had knowledge of the mine at the time of purchase, A gets certain rights. He may either repudiate the transaction or choose to adopt it, depending on what he prefers. These illustrations highlight an important principle. An agent must disclose all material facts and must not take advantage of his position for personal benefit. Any concealment or conflict of interest gives the principal the right to cancel or question the transaction. Let us now understand the duty not to make secret profit under Section 216 of the Indian Contract Act. This section protects the principal from any hidden or unfair gains made by the agent. According to this provision, if an agent, without the knowledge of the principal, deals in the business of the agency on his own account instead of on behalf of the principal, then the principal is entitled to claim any benefit or profit that the agent has gained from such a transaction. In simple terms, the agent cannot secretly benefit from the agency relationship. Any such profit belongs to the principal. Now, let us understand this with an illustration. A directs his agent B to buy a particular house for him. B dishonestly informs A that the house cannot be purchased. However, B himself buys that house for his own benefit. Later, when A discovers the truth, he has a legal right. A can compel B to transfer the house to him at the same price at which B purchased it. This clearly shows that the agent cannot misuse his position for personal gain. The law ensures that any secret profit made by the agent must be returned to the principal. Let us now understand the duty to remit sums under Section 218 of the Indian Contract Act. This section clearly states that an agent is bound to pay to his principal all sums received on his behalf. In other words, whenever the agent receives money while acting for the principal, that money belongs to the principal. However, the agent is allowed to make certain lawful deductions before remitting the amount. These include his legitimate expenses, his agreed remuneration, and any other dues that are legally payable. After making these deductions, the agent must promptly transfer the remaining amount to the principal. He cannot retain the money unnecessarily, use it for personal purposes, or delay the payment without justification. If the agent fails to fulfill this duty, he will be held liable for breach of duty. Thus, this provision emphasizes honesty, accountability, and timely payment in the agency relationship. Let us now understand the duty not to delegate under Section 190 of the Indian Contract Act. This duty is based on an important legal principle, delegatus non potest delegere, which means that a delegate cannot further delegate. An agent is appointed based on personal trust and confidence. Therefore, he is expected to perform the work himself. According to this section, an agent cannot lawfully employ another person to perform acts which he has expressly or impliedly agreed to carry out personally. However, there are certain exceptions to this rule. Delegation is allowed when it is permitted by the ordinary customs of trade, when the nature of the work requires a subagent, or when such delegation is impliedly or expressly allowed by the principal. So, while the general rule is that an agent must act personally, the law recognizes practical situations where delegation becomes necessary.